11 steps of the probate process. Most people have never dealt with probate before, and the first time you go through it, it can feel overwhelming. But here's the thing. Once you understand the steps involved, the whole process makes a lot more sense. So stick with me to the end. I'm going to walk you through all 11 steps of the Missouri probate process so you know exactly what to expect from start to finish. The probate process is administered and overseen by the county probate court. While every estate's a little different, the following steps outline how the process typically unfolds here in Missouri. Hey, Terry Peterson here with a quick interrupt. I talk with people every day just like you that are managing an estate, probate, or exploring senior transitions. I open my Rolodex of service providers, contractors, and professionals I've amassed over the last 20 years to help our clients meet their obligations in managing the estate. I invite you to reach out to me via text, phone, or email. Now back to the video. Step 1, will authentication and engaging an attorney. The first thing that must happen is determining whether the decedent left a will. If the will exists, it must be filed with the probate court in the county where the decedent resided within 1 year of the date of death. After 1 year, the will becomes legally ineffective. The court then verifies its legitimacy before anything else can move forward. If there's no will, the decedent is said to have died intestate, and the estate will be distributed according to Missouri intestate succession laws rather than the wishes of the deceased. This is one of the most important reasons to have a will in place. Regardless of whether a will exists, Missouri law requires the personal representative to engage a licensed probate attorney. A non-attorney cannot legally represent an estate in Missouri. In both supervised and independent administrations, an attorney must be involved. Your attorney will guide the process from this point forward, helping to ensure all deadlines are met and no costly mistakes are made. Step 2, small estate exemption. Before proceeding with full probate administrations, it's worth asking, does the estate qualify as a small estate? Under Missouri law, if the total value of the estate is $40,000 or less, an heir may file a small estate affidavit with the probate court, bypassing the full probate process entirely. This simplified process is faster, more affordable, and can even be filed more than 1 year after the date of death. If the estate exceeds $40,000, full probate administration will be required, and the following steps apply. Step 3, appointment of the personal representative. Once the court accepts the filing, a personal representative is formally appointed. If the decedent died testate, meaning with a will, the will itself typically directs who that person should be. If the decedent died intestate, meaning without a will, the court will appoint an administrator to fill that role. The personal representative is the individual legally responsible for managing the estate throughout the probate process. Step 4, posting a bond. Upon appointment, the personal representative is typically required to post a probate bond. This bond acts as a financial safeguard, ensuring the personal representative fulfills their duties in accordance with the will and Missouri state law. In some cases, if the will specifically waives the bond requirement, this step may be skipped. Step 5, letters of administration. The court then issues the official legal authority for the personal representative to act. If there is a will, these are called letters testamentary. If there's no will, they are called letters of administration. Either way, these documents are essential. They authorize the personal representative to access accounts, manage assets, and conduct business on behalf of the estate. Step 6, locate and protect all assets. With legal authority in hand, the personal representative is responsible for identifying and securing all assets of the estate. This includes real estate, bank accounts, investment portfolios, vehicles, collectibles, artwork, and more. All assets come under the exclusive control of the personal representative. During this phase, it is their duty to protect those assets until the estate is settled. Now, step 7, appraisal of assets. Once all assets have been located, they must be professionally appraised to establish their fair market value. The personal representative then files a complete inventory with the court, reflecting the overall value of the estate. This step is critical as it forms the basis for debt payments, tax filings, and final distributions. Step 8, creditor notification. The personal representative is required to notify all known creditors of the estate. Under Missouri law, creditors are given a 6-month window from the date of publication to file any claims against the estate. The attorney will typically publish a notice to creditors in a local periodical and check for any existing Medicaid liens through the Missouri Health Net Estate Recovery Program. Step 9, payment of debts. Once the creditor claim period has closed and valid claims have been reviewed, the personal representative may liquidate certain assets to satisfy those debts. Debts are paid according to the priority order established by Missouri law, meaning some obligations, like funeral expenses, must be settled before general creditor claims. Step 10, file a tax return. The personal representative is responsible for filing the decedent's final personal income tax return for the year of death and for paying any taxes owed from estate funds. An accountant familiar with the estate tax matters is a valuable resource at this stage. Your probate attorney can provide a referral if needed. Now, step 11, distribution of remaining assets. Finally, once all debts, taxes, and administrative expenses have been settled, the personal representative distributes the remaining assets, including cash, to the beneficiaries as directed by the will. If no will exists, the distribution follows Missouri intestate succession laws. Once distributions are complete and the court approves the final settlement, the estate is officially closed. Now, bonus info. Real estate in Missouri. Real estate can be sold during probate as soon as the personal representative is appointed and authorized by the court. The sale can proceed if the property is needed to pay estate debts, to make distributions, or if the will explicitly grants the executor the power to sell. When the sale can happen? Early in the process. Once appointed, the personal representative can petition the probate court for permission to sell the property before the estate closes. Mandatory creditor period. Missouri law mandates a minimum 6-month creditor notification period from the date of first publication. While you can sell the real estate during this time, final distribution of the proceeds to heirs cannot happen until the 6-month window closes and the estate is settled. Requirements for the sale. Court approval. Unless the will grants the executor independent administration, power to sell without the court intervention, you must file a motion asking the court for an order to list and sell the property. Once an offer is made, a second petition to approve the specific sale price and terms is typically required. Price restrictions. In supervised estates, Missouri law generally requires that the real estate not be sold for less than 75% of its appraised market value without specific court approval. Exhausting personal property. Under Missouri law, personal property must be sold to pay off estate debts before real estate is ordered to be sold, unless the court orders otherwise. And those are all 11 steps. I hope this gives you a much clearer picture of what lies ahead. Probate doesn't have to be intimidating, especially when you have the right people in your corner. If you'd like to go deeper on any of these steps, we've got you covered. Check out our YouTube channel where we have individual videos dedicated to each of these topics, along with a wide range of other probate-related subjects that can help guide you and your family through the process. We have a wealth of additional helpful resources on our website as well. Thanks so much for watching, and we'll see you in the next video. Please feel free to reach out to me, Terry Peterson, with any questions. I'm here to help. Take care.